Hello, I'm David Hicks of the Alliance Legal Group. Today I'm here to talk to you about foreclosures. Here's a brief overview of the process. In the state of Florida, foreclosures require a judicial proceeding to foreclose a lien on real property and establish the amount of indebtedness due from the mortgager. Here's a summary of the foreclosure process, which typically begins when you miss 3 to 4 mortgage payments. First, the complaint. A preliminary title report is pulled by the foreclosing lender's attorney, and this discloses all parties having a record interest in the subject property and any title defect that may exist. The complaint is drafted, naming all parties with an interest in the property as party defendant. The complaint sets forth the plaintiff's claim for relief of foreclosure and must include the mortgagor and/or owner of the property, as well as other properties having junior liens on the real property. The complaint is filed in the county in which the property is located, and a summons issued to each defendant. After the complaint is filed, a lis pendens is recorded against the property. The lis pendens serves as constructive notice to the world that a foreclosure has been filed, and that any interest acquired after the date of recording is expressly subject to the foreclosure action. Any interest in the property arising or recorded after the filing of the notice of lis pendens is cut off by operation of law. These individuals need not be made parties to the action to have their claim foreclosed. Service of process is next. This may be perfected in person by the sheriff or special process server. If service is not perfected on any party, after due diligence, service may be obtained by publication. The court does not obtain personal jurisdiction over any defendant served by publication. In addition to publication, an attorney ad litem is appointed to represent the interest of any absent defendant. This may cause some delays in the proceedings because this attorney must be served. Now we'll go into judgments. Once the defendants have been served, they have 20 days to file an answer and defenses or counterclaims. If the defendants fail to file responsive pleadings within the 20 days, the court will enter an order of default. This order of default admits the plaintiff's case and allows summary proceedings to continue. The attorney submits a judgment for foreclosure, proof in the form of all original mortgage documents, and an affidavit of indebtedness. In many jurisdictions, the default judgment may be submitted by mail without a formal hearing. In those cases in which the defendants have filed responsive pleadings, the matter is scheduled for hearing on the plaintiff's motion for summary judgment. In the majority of contested cases, judgment will be entered in summary proceedings based on proofs by affidavit. Only in rare instances will a full trial on the merits be necessary. Now we move on to the sale. After the entry of the final judgment of foreclosure, a clerk's sale is scheduled. In most cases, the sale is scheduled for 30 to 45 days from the entry of judgment. It is possible to ask the judge to put the sale date further out at, say, 120 days if the borrower is attempting a short sale or a loan modification. Notice of the sale must be published for 2 consecutive weeks in a newspaper of general circulation in the county in which the property is located. The clerk of the circuit court conducts the sale. The attorney for the plaintiff submits a bid on behalf of the lender in the full amount of the judgment or in any lesser specified amounts. Now we get on to redemption. Florida statutes do provide that a mortgagor and any other defendants in a foreclosure proceeding have until the foreclosure sale is complete to redeem the property by paying off the entire amount of the indebtedness. A foreclosure sale is complete when the clerk announces the identity of the successful bidder and issues a certificate of sale. Typically, this happens the same day that the foreclosure sale is held. The Florida statutes provide that there is a 10-day period following the foreclosure sale during which objections to the sale can be filed. If no objections are filed within the 10-day period, the clerk will issue a certificate of title to the successful bidder.